Forget New Year, New You. This season is about slowing down, locking the doors, and cozying up at home with the one you really want to do nothing with. Your dog. After the holiday chaos, those quiet nights with a blanket, a podcast, and your pup feel like the reset you actually need. Ollie helps make those moments easier with fresh protein-packed meals made from real human-grade ingredients, so your dog can enjoy some quality comfort food too. Choose from 5 recipes and get a personalized plan for your dog's needs. Meals arrive perfectly proportioned with a scoop and storage container, so serving is fast and mess-free. And with Ollie's in-app on-demand health screenings, supporting your dog is easy, ensuring more cuddles for many years to come. Visit ollie.com/truecrime and use code TRUECRIME for 60% off your first box.
This Court Junkie Brief is sponsored by, you guessed it, Lifeway Kefir. Lifeway Kefir is responsible for those delicious little cultured dairy drinks that you've probably seen in the dairy aisle of your local grocery store, or you've heard me talk about them a billion times on this podcast. Well, not only are they delicious, but they're high in protein, calcium, and vitamin D. They're also 99% lactose-free. To get a coupon and try them for yourselves, just go to lifewaykefir.com/courtjunkie. That's Lifeway, KEFI.com/courtjunkie. Hi, this is Jillian, and you are listening to a Court Junkie Brief on guilty pleas from a prosecutor's perspective. I've been wanting to do a brief on guilty pleas for a while now. I have followed a lot of cases, and undoubtedly you have too, where a defendant takes a guilty plea, and it just doesn't always seem right. Whether it seems like the defendant is getting off with a lighter prison sentence than they deserve, or whether someone has pleaded guilty even though you're not exactly sure that they are in fact guilty. But what do I know? So I wanted to get the perspective of a prosecutor, someone who makes plea deals all the time and is actually an advocate for them. So in today's brief, I did just that.
My name is Dave Wenger, Wenger, and I'm a prosecutor. I've been a prosecutor for nearly 5 years in Pennsylvania.
I already knew what questions that I had about plea agreements, but I wanted to get some listeners' questions in too. So I asked the people in our Court Junkie Facebook discussion group what questions they have about plea deals as well. So in this brief, I asked Dave my questions and yours, and then I asked him to answer to some of the negative aspects of plea deals. And so, here we go. Beginning, of course, with the basics.
So plea bargaining, and I think it varies from jurisdiction to jurisdiction, but in Pennsylvania in particular, and I think most jurisdictions, plea bargains are, there's 2 parts of any plea. You have the part of the crime in which the defendant is agreeing that they have committed, and then there is the second part, which is the sentence. And in Pennsylvania, the prosecutor and the defense cannot plea to a sentence by itself. The court does not have to accept that. We can recommend it, and I would say 99% of the time the court does accept the sentence agreement that we've come up with, because that's part of the discussion during the plea agreement, but they don't necessarily have to take it. So there's 2 parts. You have your guilt part, guilt of the crime, and then the sentence part as to what your punishment is going to be.
And can you explain the process of a plea deal? Like, how does it work? Because I know a lot of people were asking, like, does the defense usually approach the prosecution? Is there like a specific way in which it works, or does it work both ways?
It works both ways, and I think most of the time it works as to whoever has the weaker plea approaches the other side first. So oftentimes you'll be charged with, a person, like in a drug case, will be charged with a plethora of crimes, from possession with the intent to deliver, to possession of a controlled substance, to possession of paraphernalia. And all of those can be one thing. They can have an amount of, let's say, cocaine in a bag. Well, they could have enough cocaine where we believe that that amount is used to distribute or sell to someone. They have that amount of cocaine in their possession because they just have it in their possession. And then they have the paraphernalia because the baggie that is holding the cocaine is paraphernalia. So depending on the circumstances with how the police discovered these drugs can determine what the plea may be. So for instance, let's say the police were called somewhere and they stop a person. Let's say they were called because a boyfriend and girlfriend were arguing and it was loud and their neighbors called, and they just show up and they decide that for officer safety, they do a pat down of both people, and on one of the people they find some cocaine in their pocket and maybe some cash. We could theoretically charge possession with intent to deliver. There's no weight that says this is delivery, this is not delivery. But so let's say we charge it. Well, we may reach out to the defense, or the defense may reach out to us and say, hey, this is really a possession case. Do you agree? And oftentimes the prosecutor, our job is not to convict people. Our job is to do justice. So we can come to a point where we say, yeah, that's probably fair. I agree that this person was probably not intending to deliver their drugs, which would be different from someplace if we did a controlled buy where we sent somebody out into the street and said, hey, go buy $20 worth of drugs off that guy. Well, that's different because now we know that that's what the purpose of him having those drugs was for.
I asked Dave what sort of factors he considers before going into a plea deal. In our discussion group, Dina wanted to know if the victims' families typically have any input. As a prosecutor, what factors do you consider before agreeing to a plea deal? Like, what do you take into consideration?
So there's a few things. One is what kind of job did the police do in investigating the case? So just like anything else, there's sometimes where an officer may have a bad day and they didn't do as good of a job as you wanted them to. But usually that's not the case. Usually what happens, where the cases a lot of times are tough on any type of case, is when you have witnesses. And if the witnesses have some loyalty to someone, their stories may change, or they start to forget things, or they do a number of different things that cause problems within your case. And what we're trying to do is we're trying to find out the most just result that we can get for a particular case. Now, there is a difference, I think, or should be a difference anyway, when you have societal-based crimes versus personal-based crimes. We can talk about that in a second, but there's certainly a difference between those two and how we deal with police. So when we're dealing with like a societal-based crime, that's where the prosecutor will talk to the officer and say, hey, this is probably the best that we're going to get, or what were you sort of looking to get out of this when you arrested them, sort of what was your end goal? And so that'll help determine where we go with a plea agreement. When we have a personal-based crime where it's a robbery or a rape or an assault, we definitely want to have the victim's input inside that discussion. Now, the one thing with victims, though, the one thing that I've learned as a prosecutor, which we've recently taken steps to change, is there's always been this, the victims always tend to seem to be on an island. The system's happening around them, and they're kind of looking at this giant system working step by step, and they don't really know what to do, and nobody's really communicating with them. And when they do communicate with them at the very last minute, and they're kind of overwhelmed with the whole situation. So I think that has to be a better job done by more prosecutors and the system as a whole. If it's not the prosecutors in your victim witness area of your DA's office, or however the situation is, but there definitely needs to be more victim focus when you're dealing with personal cases, when you have a person as your victim.
Right. Or even like a victim's family, right?
Yes. Like in a murder case or something like that, where their victim is no longer there, or they're too hurt, or they're a child, whichever those cases may be.
Gotcha. So in your experience, you would say that taking a victim or a victim's family is a consideration when you are considering a plea deal?
Yes, it should be. I mean, for me it is, and it should be for everyone.
Right. And so there's no standard to where the victim's families, have to have some sort of input into those arrangements. It's solely up to the prosecutor?
Yes, or the office. So the district attorney themselves, or the head of whatever division you work in, could have a rule that says you are not allowed to take a plea agreement until you reach out to the family. Now, I guess the ultimate rule is that it's never the family's decision. the end decision is the prosecutors. And the reason for that is, unlike a normal attorney-client relationship, the victim is not the client of the prosecutor. The state is. So there's not an attorney-client relationship that exists between the prosecutor and the victim. So it does put you in a situation where there may be a disagreement between the prosecutor and the victim, but I believe that so long as the prosecutor is in full communication with the victim, going over the rationale as to why the plea agreement makes sense versus not doing a plea agreement, even if there's a good case, as long as the family is involved with that throughout the process, I think that conversation becomes a little bit easier. Unfortunately, I don't think that is always the case, because I don't know if it's the prosecutors are busy or what the scenario is, but I know that's sometimes a lost art.
Another thing that I wanted to know is, how often does a prosecutor consider a plea deal? When you get a case, is it kind of at the forefront of your mind to try and see if a plea deal can be reached prior to even thinking about going to trial?
It depends on the case. Cases are difficult. When you have societal crime cases, drug cases, traffic cases, things like that, those are, yes, you're looking for a plea agreement pretty regularly, unless there's some reason that you're not. I mean, there would have to be something that you're not going to look for. Now, that doesn't mean I'm looking to let them walk away at some easy thing. I mean, a plea agreement could be to the highest charge.
Right.
It just may not be to the 6 subsequent charges after that, just the highest one. But you're always looking, if there's a plea, where am I kind of going to be in a plea? I think that's really with any case. If there is a plea to be had, where is it? Is it on, I'm taking the top charge, or someone placed in the middle, I guess? So I guess to answer your question, I guess always we're looking to see if there's a plea agreement.
Gotcha.
Some cases, though, like child rape cases and sexual assault cases and murder cases, those we take a different look at. Those are like, okay, there needs to be a reason that I'm moving anywhere on this case. You need to, there needs to be something solid as to why I would agree to a plea. And sometimes it's when you have a child victim, they just don't want to testify. They're scared and they're not going to. And you can make them, and you feel bad if you have to make them, because they do have to do it. But sometimes the perpetrator will say, well, I'd rather not risk more time and I'll do less time, because that sometimes does happen, especially in those types of cases.
Another member of our group, Julie, wanted to know about the judge's involvement in plea deals. What about the judge's role? Like, can a judge refuse or overturn or even alter a plea deal, or is that strictly between the defense and the prosecution?
The judge can either accept or deny the plea deal. They cannot. They can offer suggestions, but they cannot alter it. Their role does not allow them to step in and say, nope, we're going to move this here and there. Coming to a position where, let's say you're really close on a plea agreement between the prosecution and the defense, but the defense isn't willing to come up to where the prosecutor wants, and the prosecutor isn't willing to come down. The judge may stand in and say, okay, have you guys thought about maybe this direction? And then the prosecutor and the defense attorney talk about it. But the judge cannot just come in and say, you've agreed to A, I'm going to make it B, and that's the way it is. That can't happen. He can't refuse it. He can say, we've come to agreement of A, and he can say, I don't accept that.
Oh, okay.
So he can do that. Judge also will look at the how just that result is, and if he thinks it's fair or unfair, he has the discretion to say, I refuse to take it. That rarely occurs, because he's not involved in every aspect of the case. He's trusting the attorneys that are handling the case to go there. But I know sometimes where that becomes important is, let's say you have like a felony murder case where you have 3 guys that go rob another guy, and one of those people of the 3 robbers ends up shooting someone. Well, all 3 of them are guilty of murder under the law. But the prosecutors may want to give guy 2 and 3 who didn't shoot him a really good plea agreement to go after the shooter because, okay, yeah, they robbed him. That's a crime of violence, and they are going to have to face some punishment, but do they necessarily need life in prison? No. So there may be a situation where a prosecutor and defense agree to, some period of time, like, the shooter is a really bad guy and we want to go after him. So let's give this guy 5 years for his role in this. Well, a judge could say, no, I'm not accepting it. He deserves more than 5 years. So they could stop it there. Or you could have one where it says, we're going to agree to this sort of longer sentence, and the defense agrees because they're worried about an even longer sentence, and the judge can say, no, that's too unfair the other way.
And what about juveniles? Dennis had a great question about plea deals involving juvenile defendants. What about when the defendants are juveniles? Are the parents or guardians involved at all in that?
They are.
Yeah.
They are involved to the extent that the juvenile can, at a certain age, and I think it varies. I think it's 15, can say, I don't want to talk to my parents about this, so they can choose. But the court always makes sure that they had the opportunity to speak with their parent or guardian.
Another question from our discussion group, Shay wanted to know why there's such a discrepancy between co-defendants. And this is definitely something that we see often.
Yeah, I think the biggest reason is culpability. So who you find is the most culpable person within what's been charged. Because although there are 3 people or 2 people or 5 people that all commit the same crime, somebody's the ringleader and somebody's just the follower. And if we want to get the ringleader, sometimes we need the follower to tell us who it is. And if we know who the ringleader is and know who the followers are, we're more likely to give a plea agreement to the follower, because maybe we can't get the ringleader because they're smart and they were not the ones to get really caught up in what was going on, because they've been doing this a while and they know kind of how to do it. That's why they're the leader. So sometimes we need the underlings to go after the big guy. And sometimes that's more important.
To Dave's point, perhaps sometimes it is more important to get the ringleader, so to speak. For anyone following the Teresa Sievers case, this might make more sense. Teresa was a doctor from Florida who was murdered in 2015. Investigators arrested 2 men in the case, one of them who happened to be a childhood friend of Teresa's husband. And it was clear that investigators did not believe that the 2 men had acted alone. So in 2016, a plea deal was offered to the husband's friend. And sure enough, he then implicated Teresa's husband, who was then arrested afterwards. This case has not yet gone to trial, but it's somewhat easy for me to see why getting the arrest of the husband, who may have been the mastermind, was so important. Because if he's proven guilty, then that will take him off the streets, and perhaps even more importantly, away from the couple's 2 young daughters. Now on to what might be the most interesting part of my interview with Dave, getting his take on the arguments against plea deals. So the first thing I wanted to bring up was the argument that plea deals can be somewhat coercive. For example, there's some controversy over the fact that some people are offered a plea deal that is oftentimes a better option than going to trial and risking being put away. Many people argue that this can lead to a false confession for those people who are truly innocent. I directed Dave to some statistics I found on guiltypleaproblem.org, and one of the stats you'll hear him reference in this next clip is that 345 exonerees pleaded guilty to crimes that they did not commit.
And so it appears that they've had 345 exonerees plead guilty to crimes they did not commit. Now, I don't know over what period of time that 345 comes from, but let's just say it's from 2015 for 1 year. Let's say there's 345 exonerees in 2015. There were about 50 million criminal cases in 2015. So that number of 345 is 0.000069% of all pleas. So it's a really small number, and I don't mean to say that false confession, because one reason, as a prosecutor, the thing that I would not want more than anything, I would rather have a guilty person walk free than an innocent person go to jail, especially if it was me that did it. I have a very big problem with putting innocent people in jail. I don't ever want to do that. But could it happen? Based off of your suggestion, it's possible. But there's a couple of things that are going on there, I think, that take it away from the prosecutor's kind of position and really put it back onto the defense's position. If the defendant didn't do it, the prosecutor has given the defense all of the reasons. We've given them all of the evidence as to why we believe their guy is guilty. And we have these reasons, and we've taken it through a probable cause hearing where it shows that the crime was committed and it was likely committed by this person. We have a prosecutor reviewing it along with police. And we have a lot of cases, and we don't have time to go after innocent people. But it could happen, of course. But the defense is in a different position than we are. They get to talk to their client, and the client can explain to them why they didn't do it, or they did, or just say, or say nothing. And so I think so long as the prosecutor and the police, which I will say applies to most of us. I mean, every job has a bad fish somewhere. It doesn't matter the field that you're in. But most of us are really out there to try to do a good job. We're there to try to make sure justice is upheld. So, yes, there could be a small percentage of the population that is coerced into taking a plea agreement, but I don't really think it's a majority of the people that plead guilty. I think most people that plead guilty because they did it.
The next argument I wanted to make was on behalf of Salmon Deep, another Facebook discussion group member. So the second argument would be that it endangers the correct legal outcome. And I got a comment from one of my listeners, so I'm going to read that to you, and because it kind of goes along with that sentiment. So he said, "To be honest, the whole idea of plea deals seems wrong to me, regardless of whether the defendant is guilty or not. If they are guilty, they should receive the right amount of prison time, and if they are innocent, the statistics of defendants that go to trial receiving sentences 3 times as long might scare them and force them into taking the deal." So kind of like what we just talked about. And then he said, "Surely there can be a better system to prevent courts from getting overcrowded." So he basically is just saying that he thinks that it basically endangers the legal outcome. So like a person who's really guilty, instead of getting the correct prison time that he would normally get, his sentence is shortened and that kind of thing. What do you think about that?
And I think that's probably where the majority of the questions regarding plea deals comes from, and at least in some general aspect of how they work. So let's take an example of a theft case from Walmart. I'll do a theft case from Walmart, then we'll look at like a murder case. So if they could have stolen, let's say, $550 worth of things, and they would be subject to a misdemeanor of the first degree. If you go down below $550, they would have a misdemeanor of the second degree. Now, their maximum penalty that they're going to receive on a misdemeanor of the first degree would be 5 years. The maximum penalty that they could receive on a misdemeanor of the second degree would be 2 years. Well, in Pennsylvania and many other jurisdictions, the legislatures have come forward with a sentencing guideline matrix. And I can send you a link to the Pennsylvania one, just if you want to put it in the show notes or something, so somebody could look at it.
Yeah, that'd be great.
Okay. How this works is what the judges sentence you to. Okay. So what that is made up of is two numbers. The first number is your prior record score, or what you've done as a citizen in the past in your commission of crimes. What kind of criminal have you been? So that number in Pennsylvania anyway goes from 0 to 5 on the point total. And then there's 2 additional categories for somebody that is a repeat felon or a repeat violent felon. But we'll just deal with the 0 to 5. So if you're stealing something from Walmart and it's the first time that you've ever done it, you're going to have a 0 prior record score because you've never done anything before. This is the first time you've stolen anything. The next number you look at is the offense gravity score. So you have a score that is associated with the crime in which you've committed today. So that can range in Pennsylvania from 14, which would be a murder, all the way down to a 1, which would be stealing a package of gum from Walmart. So if you have a 1 and a 0, which would be a theft from Walmart of a pack of gum, your sentence would be what is called restorative sanctions, basically probation. That category, the restorative sanctions category, covers a lot of the bottom end of a sentencing area. So there's a lot of crimes that you can commit, even with a higher prior record score, and it'll be easier if somebody's looking at it because it's hard to explain in full, but that will encompass a lot of things. So back to the misdemeanor 1 versus misdemeanor 2. Those 2 crimes are only going to be 1 point off in offense gravity score, which means that there may not be any difference in the punishment based off of the sentencing guidelines. Although their maximum punishment could be different, their actual punishment won't be. So the plea agreement may be to the lesser crime, but it doesn't really make a difference to their punishment. They will still owe the amount of money they stole from Walmart, and they will still get the same penalty that they would have gotten had they pled to the higher offense. So let's take a murder case, though, for instance. So if you're convicted of first-degree murder, it's a life sentence. It's a life sentence. You don't have, there's no possibility of parole. You're just going to prison for the rest of your life. But let's say how that happened is the person broke into the house and beat them up and then killed them. Okay, so you have 3 crimes there. You have a burglary, and then you have an assault, and then you have a murder. So you have three separate crimes. Now you could reach out to a family or the prosecutor, and you're saying to yourself, well, if we agree to a sentence that's, let's say, 40 to 80 years, that, this character is 30 years old, the minimum he's getting out when he's 70, at the maximum he's getting out when he's 110, you could think about it. So let's say there was an agreement to come to there. Why would a prosecutor do that? Why would a family want to do that? Even though he should get a life sentence. Well, there's a couple of reasons. The first is, how strong is your case? How much evidence do you have? How much do you think that it is a guarantee that a group of 12 jurors will find this person guilty? So what does a plea do? Well, it takes the jury out of the mix. You don't have to go on a weird sort of tangent when you have jurors, because as a prosecutor and being in front of a lot of juries, jurors do weird things. They make weird decisions that aren't even brought into court. They make up their own mind. They're people. A defense may not even bring up an argument of something, yet the jury in their deliberations comes up with their own argument. And I'll kind of sidetrack here for an example of this. There was a rape case that we had 3 nieces who said their uncle had sexually assaulted them. And one of the girls said that she can show, she says, when my uncle cleaned himself up after raping me, he had a condom and he went to the sink, and I saw when he took off the condom, the semen went to the floor, and he covered it over with a rug. So when the police went to the house, or to the house where this happened, they go to that rug, lift it up, find his semen there, take it in, run the DNA, it matches the defendant, right exactly where the girl said it would be. Well, somebody in the jury that we find out after they acquitted him, someone in the jury said, oh, the police must have planted it. Now, the defense never brought up that argument. It was never brought up anywhere in the trial or in closing argument. Just some juror in the back said, oh, the police could have planted that. So that turned the whole trial around. So that's where the risk is with going to trial. So where the advantage is you have a guaranteed sentence. So this family can say, you know what, my daughter or my spouse or whoever, my loved one who's died, was 30 years old, in 40 to 80 years, they would probably have ended their life naturally at that point had they lived. So it really is kind of a life sentence. We'll agree with that. So we're guaranteed that this bad guy is going away for this amount of time. So that's reason one. The second reason is appeals. You don't have any appeals when they plead guilty. That is taken away. The only time that an appeal would apply, with some of the exoneratory things that happen when there's a plea, is if there's newly found evidence that fully exonerates them. So that would be, but generally speaking, again, that number has to be very, very low in the grand scheme of how many people have pled guilty to things. So that really removed the appeal process. So you don't have any, you save money, time, energy, and it's just the case is done. They go do their time, and whenever they're up for parole, there's an argument by the prosecutor and or the family that says they should stay in, and the parole board decides that they stay or go home.
Now, the next question, I felt a little bad being so straightforward about, but it's definitely something that people think. So I wanted to ask it. Okay, so another argument that I wanted to bring up is that prosecutors are motivated by conviction rates. So does it affect a prosecutor's conviction rate? And if it does, is that something that you guys care enough about to push for a plea deal?
Okay, so I don't know how PG your show is, but only jerky prosecutors are caring about their conviction rate. I mean, do we care about winning? Sure. Is anybody sitting there saying my conviction rate is this? No. I mean, maybe it's something you use when you're trying to go head to head with a defense attorney saying, look, you know my reputation. I don't lose often. But is it something that, like, do we have little boards in the back saying this is my prosecutor? No, and plea deals don't have anything to do with it. Now, does that mean there's not some jerky prosecutor guy that's doing that? There probably is.
Right.
I went to law school. I know jerky people. So, so yes, is there someone out there doing it? Probably. But are the majority of us doing it now? I think the majority of us are trying to find the best just result for the community in which we live.
Does it even affect your conviction rate, though? I mean, does that count as a case that you won if the defendant pleas?
If I were to do my own conviction rate, I guess to answer that question, since we don't do it, I would say no. I only go to the cases that I take to trial. I don't care about pleas. Pleas are always a win. I guess there is something to be said there. I guess I could say this: if kind of a win-loss. If let's say we offer a plea agreement of the defendant is charged with A, B, and C, and we offer B and C as the plea and not A, and the defendant doesn't want to take it. If he only is convicted of C, so we got a conviction, but it's less than our plea agreement, I guess I'd lose that case, even though I technically got a conviction because it was less than the plea agreement. That would be one way to look at it. Like the defense can say, oh, but we won because it was better than your plea agreement. And we can say, oh, well, I guess we lost because it was worse than ours. That would be sort of where it falls out.
Another argument that I've heard and wanted to bring up to Dave is that prosecutors and defense attorneys are more so thinking about themselves when they're looking at plea deals. The accusation being that maybe they don't want to take it to trial for their own selfish reasons.
There's never a benefit to me or the defense attorney or any prosecutor, defense attorney at all. Now, I don't, not as a defense attorney, I never actually practiced as a defense attorney. The one area that would be interesting, I think, for you to follow up with maybe a defense attorney would be the cost of a trial versus the cost of a plea.
Yes, I was going to bring that up.
I don't know because I've never been a defense attorney, but I know that sometimes there are varying costs to what the attorney is doing. So I guess there's a potential for a defense attorney to have some incentive one way or the other. But from a prosecutor, we're salaried government employees. We don't make any money, and we go about our cases as they come. And same with public defenders. I mean, they certainly have no incentive. So if there's an incentive anywhere, it would be maybe in the private defense side.
I know quite a few of you had questions about the Alford plea. And for those of you who aren't familiar with that term, An Alford plea is essentially a guilty plea in a criminal court where the defendant does not admit guilt and instead asserts innocence. But by entering an Alford plea, the defendant admits that the evidence the prosecution has would likely be enough to persuade a judge or a jury to find the defendant guilty beyond a reasonable doubt. And while I didn't want to get too much into it, I did ask Dave about Alford pleas. And yes, I did bring up the West Memphis 3.
Okay, so the Alford plea is fine. The Alford plea is basically, I am too intoxicated to know what I did, but if the Commonwealth or the state presented this evidence, the jury would likely convict me. So they're basically saying, I don't really remember what happened, but if this evidence was presented at trial, it's likely that a jury would find me guilty. Now, I know there's, I guess, some theoretical issues with how can you commit a crime if you don't know? Well, the only time that intoxication is really a defense to anything is in first-degree murder cases. So you put yourself in a position to do there, and we still have to prove beyond a reasonable doubt that you did this thing. So if you believe that based on the evidence, beyond a reasonable doubt, the Commonwealth would show that you committed this crime, then I don't have a problem with the Alford pleas, although I could see where somebody may have some concern of it being taken advantage of. But really, I don't have a big issue with the Alford pleas.
Did you follow the West Memphis 3 case at all? They took an Alford plea, right? So they were already in prison for however many years, and then instead of going through another trial, they took the Alford plea and then were let out of prison. What are your thoughts on that, like in relation to that situation?
So they made a decision that I don't think that I would offer as a prosecutor. I think I would have just let them walk away from it. I don't think that was the right decision by the prosecutorial office in that case. I thought it was pretty clear that they didn't do what they did, but they, for whatever reason, the prosecutors wanted them to have some sort of guilt on them, and they agreed because they got to just walk away from it. And the reason why it works that way is they don't have to make an admission to that they're guilty. They just have to say that if the evidence was presented, they would be found guilty. So there's no admission by the defendants that they committed the crime, just that basically in exchange for getting out of prison today, I'll say, fine, yes, you guys proved it. Sure.
Right.
It has, the only impact that it has is these guys are not exonerated. And that's really the unfortunate part about the whole situation is they didn't do it. The prosecutorial office should have said they didn't do it and just withdrawn the case and said, no, you're right.
Right.
But I don't work there.
Right. No, we're not blaming you. Don't worry. Can that case then can anybody else ever be tried after an Alford plea is taken? Like if, say, the police in Memphis come across some new evidence that proves that, one of the fathers of the children or whoever was the actual killer, can they then go and try somebody else for that case? Or because those 3 took the Alford plea, is it kind of closed?
No, because there's no statute of limitation on murder. So if you find somebody did it, and that would actually allow those guys to then subsequently become exonerated. Gotcha. Because they found new evidence that said, we didn't do it, this guy did it. And so take our Alford plea away, that then gets wiped off, and they can go after that new person.
Gotcha. And that applies for all guilty pleas also?
Yeah, I mean, sometimes you may have a statute of limitation where the new person may not be able to be convicted of the charge. But if you were able to prove after a guilty plea that you were not the person that did it, then yes, you can be exonerated.
So Dave is very much for plea deals. And from a prosecutor's point of view, I can better see how they make sense. He gave me another example of a case that he worked on.
So here was one that we had really recently that he was facing, I think, a 4 to 8 year sentence. And this is a person that in his youth was a bad dude. He had, and at some point had raped someone and had done think, 10 or 15 years in the penitentiary. But since he's been out, he has had no other crimes in his life since he's been out. And he's been on probation, and he's off probation. He's been off probation now for like 3 or 4 years, and he's had 0 run-ins. Well, when he got out of the penitentiary, as if anybody listens to other true crime podcasts and exoneree podcasts, it's hard. And even he's on an exoneree. He's a person that's guilty. So he's living in a halfway house when he gets out. And he starts a job at a bakery. And at the first couple of years, he rides his bike to work every day to get to and from work. He's never missed a day. He's never late. Rain, sleet, snow, ice. He's riding his bike to work. Over the course of time, he ends up being able to buy a car. He ends up being able to buy a house, still continues to work for the same company, goes up in responsibility, and is promoted. And so he's doing really well and has committed no crimes. But when you are a sex offender, you have to register as a sex offender, and there's very specific rules. And one of the rules is if you are going out of country, you have to let somebody know. And another rule is if you're going out of country, or if you're staying someplace other than your place of residence, you need to let them know. Well, if you're going out of country, you actually have to check both boxes because, of course, you're not. So it's one of those things. I have to check that I'm going out of country because I'm going, and I also have to check that I'm not staying at my own house. Although somebody may not realize that you have to do both because, of course, you're not staying at your own house when you're going out of country. Well, he forgot to check the box that said he was staying somewhere else. So we get a message from Customs, or ICE, I guess it was. ICE calls us and says, hey, we've got a sex offender that's coming back that didn't fill out the paperwork properly. We need to hold him when he comes back from overseas. So we do, and he spends like 100 days in jail by the time everything kind of worked itself out to where he was released on bond. And so his sentencing came up, and he pled guilty to the crime that he committed because there's not really any wiggle room with that crime. We don't let anybody get out of it, but he was facing 4 to 8 years. And we decided as an office that he should only get probation. So even though, and he did go and get probation. So sometimes when we're looking at these cases, it's also the justness of the sentence too. So you cannot group each defendant into a group. You have to look at each of their individual situations independent of the rest of the defendants. So it's not an assembly line justice system.
But although he's definitely for plea deals, he's not afraid to say that the system isn't perfect.
I mean, the problem is sometimes the concerns are right. Complete justice isn't found. Maybe this guy did more than he's pleading guilty to, but what are we missing? I guess what is society missing by him doing that? What is it, a de minimis sort of situation where the punishment is slightly less than what was potentially deserved, or is it greater? And then on the flip side, are there potentially people that may not have committed all of that crime or only part of a crime, or maybe not that crime, that are agreeing to plead guilty? That's also possible. But again, that's in such a de minimis way. So this is a way that I think society can accept and should accept, that we come to a rational decision based on the people that we entrust to do these things, to help our justice system work. And so I think the attorneys on both sides try to come to the most fair and just result at the end of the day.
Do you think that there's anything that could be done to improve the system?
Oh, sure. I mean, the biggest thing that you can do to improve the system is put more money into it by giving defense, especially through the public defender's office, who are some of the best lawyers. The best defense lawyers in the country are public defense lawyers, not private lawyers, public defense lawyers, because they're dealing with more cases than anybody else. But they don't have the resources. I mean, the district attorney's office in and of itself, generally, in most communities, don't have a huge budget either. But what they do have are the various police budgets that get to do their investigation. I think it would be better in some ways if the public defender's office had maybe not as many resources, because I don't know how possible that would be, but have more resources so that they can do as good of an investigation on clients that they find are maybe not guilty of what they did. And then they can come and show the prosecutor, look, we've got X, Y, and Z. We don't believe that this person did it for these reasons. And you should look into this. So I think that's, if there was a way to change it, initially that would be one way to do so.
So, is there anything else that I did not cover that you would like to add?
I think the last thing, though, just when you're talking about plea agreements, the most important thing, I guess, to realize is plea agreements have to happen. The system cannot work without them. I have a caseload of anywhere between 75 and 150, depending on where things are in the process at any given time. And then multiply that by the amount of prosecutors we have. And the judges just don't have time to try all of these cases. Let's say I have 1,000 cases a month or a year, and so does everybody else. In order to try every one of those cases is going to take more time than there is in a year. And then it's not like those cases just stop. You keep adding. And so without having plea agreements, the system would just come to a halt. Now, there's a method to where you accept the plea agreements. And you can be a jurisdiction, and they vary from place to place, can be a very pro-defense based jurisdiction where the plea agreements are that the defense bar has a stronger position and is for whatever reason able to get really good plea agreements for the defendants. And sometimes you have a strong prosecutorial place where the prosecutor says, okay, this is what we're going to do and this is where we're going to go, or we were pretty comfortable about going to trial and winning, and you're facing more time. So it has to happen. And the other part, I guess, we didn't talk about with regard to why pleas work when you're talking about plea agreements is, although this is the judge's discretion, are whether things are pled where the sentences of the crimes are run consecutively or concurrently. Because if I'm guilty of 3 things, and each of those, say I get 2 years for, if I run them consecutively, well, I'm actually doing 6 years. If I'm doing them concurrently, I'm only going away for 2 years. So that also plays into a plea agreement, is how those sentences are run as well, whether they're consecutive or concurrent. But yes, but the biggest message I have is that pleas have to happen.
Pleas have to happen. That will do it for today's brief on plea deals from a prosecutor's perspective. And now I want to know what you all think. If you're on Facebook, please join our discussion group and let's talk about it there. Just go to courtjunkie.com/Facebook and you can join right from there. You can also find me on Twitter at CourtJunkiePod, and you can email me as well at podcast@courtjunkie.com. Thanks for listening. Until next time.